Hey, it's Savoy, estate planning attorney and owner of TDH Law, where we handle successions, estate plans, transfers of property, and much more. This video is the first video in a series called Let's Leave a Legacy, where I'll be answering common estate planning questions. So today's topic is answering a question that I get a lot, and that question is, what is an estate plan? An estate plan simply means to make a plan for all the things that you own to be passed on to your loved ones after you die. So, before we get into what documents that are included in an estate plan, let's talk about what happens if you pass away without an estate plan in place. In Louisiana, 3 things happen if you die without creating a will or a trust. First, all of your assets will be frozen. Assets are things like your house, your cars, your bank accounts, your businesses, and even digital assets like your stocks, cryptocurrencies, and NFTs. All of these things will be frozen. So the second thing that happens if you pass away without writing a will or a trust is that your heirs must go through a succession in order to gain access to those frozen assets. So a succession is a court-supervised process, and it means the same thing as a probate. Here in Louisiana, we tend to use the word succession to refer to the process that other states call probate. So the very last thing that happens if you pass away without writing a will or a trust is that state law gets to decide who your assets will be passed down to. Okay, so let's talk about what the succession process is like. Let's use, for example, Dad. Dad passed away 5 years ago, and he had 1 son, he wasn't married, and he owned a house. So ever since Dad passed away, Son has been living in Dad's house. But Son decides that he wants to sell the house and move out of Louisiana. Son runs into some issues when he tries to sell the house because Dad's name is still listed as owner of the house. So Son comes to see me, and I explained to him that we need to complete a succession. So we gather a bunch of information, we file a bunch of pleadings with the court, and a few months later, a judge signs off on the succession. Now, that was a fairly easy example of a succession, but oftentimes successions can be costly and lengthy because owner may have died 25 years ago and he has 12 heirs. So obviously it can get a little messy, and people want to avoid this court succession process, and they ask me, how do we do that? That leads me into my first estate planning document, which is a last will and testament. And I'll start off by saying that just by creating a will, you unfortunately won't avoid a succession. So in order to avoid succession, you must do a little bit more than create a will. So what does a will do for you? A will lets you decide who your property will be passed down to instead of the state getting to make that decision. So if a will won't avoid a succession, what does avoid succession? And the answer to that question is a living trust. A living trust is a document that, if done in the right way, your heirs won't have to go through a succession process when you die. A trust is a document where you place all of your assets inside the trust, or you retitle the property that you own into the name of the trust. A trust has 3 parties. The first party is called a grantor. The grantor is the person who creates the terms of the trust and the person who places their property inside of the trust. So terms of the trust can look like this. Let's use grandfather, for example, leaves $25,000 to his grandson John in trust, but John can't get that money until his 21st birthday. So the second party in a trust document is called a trustee. And the trustee is the person that ensures that grandson John gets the $25,000 on his 21st birthday. So a trustee is the person who handles the trust according to the terms that the grantor set out, and he distributes the assets in the trust at the end of the trust terms. So if a grantor still wants to use the property inside of the trust while he is still alive, he should name himself as trustee. But he should also name a second person as successor trustee so that when grantor passes away, successor trustee can take over in handling the trust. Now, the last party to a trust is called the beneficiary, and that's just the person or people who receive the benefit of the trust. So people create trusts for a lot of different reasons, mainly to avoid succession, and other reasons can include avoiding a nursing home taking all of your personal assets like your bank accounts and your house just to pay for the nursing home. Some families with special needs will create a special needs trust for the benefit of that special needs person. And lastly, some people create trust just because they don't trust their loved ones to not blow through their inheritance once they pass away. So the next estate planning document that I'm going to talk about is called a testamentary trust. A testamentary trust is a combination between a last will and testament and a living trust. Now, a testamentary trust won't avoid succession, but I do recommend testamentary trusts for parents who have minor children. So next up is power of attorney. Power of attorney is called mandate here in Louisiana, and a mandate is a document that gives another person your signature authority. So if a person wanted to handle your financial needs, if you were unable or unwilling to do so, then they can do that for you if they're your power of attorney. A second power of attorney document is called a healthcare directive, and a healthcare directive gives a person of your choosing the power to make healthcare decisions on your behalf if you're unable to do so. So one important takeaway about power of attorney is that it only has power while you are still living. So if you want that same person to have power once you pass away, you need to name them as executor in your will or name them as successor trustee in your trust. The very last estate planning document that I'm going to talk about today is called a living will. A living will should not be confused with a last will and testament. A living will is just a document that states if you wish to be kept alive in the event you are put on life support. Okay, so that was a lot of information in a short amount of time, but the rest of the videos in this series will dive a little bit deeper into each of the topics that I mentioned today. And as always, if you want to talk about your specific estate planning needs, contact me and we can schedule a time to talk. And remember, let's leave a legacy. If you enjoyed the contents of this video, please like, comment, share, and subscribe.